My name is Eric Bowman. I am very pleased to be joined today by Joe Flick. Joe, as Tony mentioned in the beginning, is a real estate professional with a focus on finding real estate solutions for healthcare professionals. Joe, would you like to introduce yourself and
Yeah,
tell a
absolutely.
little bit about what you do?
Yeah, absolutely. Appreciate the opportunity, gentlemen. I am Joe Flick. I'm with CAR. We're the largest tenant buyer brokerage firm in the United States that is healthcare specific. We'll go into that a little bit more, but I'm here in Central Florida, working that market. I go as far as DeLand, up to New Smyrna on the East Coast, and then down to the kind of the Melbourne area as well on the East Coast, and then over to Lakeland. So I travel a lot.
And what is it about, before we even jump into the outline here and talking about the topic today, what is it about Central Florida uh, that is unique compared to other areas where you talk to professionals in other parts of the country?
Oh man, I mean, for first of all, from Florida in general, I mean, we're the only state in the US that has sales tax on their leases. So I know they have to do completely different spreadsheets for us. I mean, in terms of Central Florida market, I know a lot of other markets can reflect this as well, but the amount of moving, especially post-COVID, that people have done from other states um, to our general geographic area and all the submarkets on the outside is just unprecedented. So markets are changing on a weekly, monthly basis, and demographic information that we might have had that's 4 or 5, 6 months outdated might not necessarily translate into the newer stuff that's becoming available. So when you're seeing 10, 15, 20,000 people move to Central Florida a month, um, at the height of that, that move down south has been, I mean, it's unprecedented, so it's tough to see.
What percentage of folks that you work with are coming from out of the area versus folks relocating within the Central Florida market?
That's a great question. I'd say probably maybe half. Most of them are, I mean, I'd say maybe 60% of the ones are actually local here to the market, either relocating, they have a lease that they need to redo, or they're a startup that live in the market and they have an area or an idea of where they want to be, and then I help them kind of fine tune where that might be as well. The others are moving from northern states. Either they have family down here already and they're following them down. I've had doctors have conversations with me from as far west as California that are interested in moving over. The idea of not having a state tax, as an automatic increase in their potential to make money down here too. So those all factor into those decisions.
So the state tax offsets the issue of having to pay a real estate tax
Right.
that gets, or a lease tax that essentially gets passed on to tenants.
To a certain degree, yes. Yeah, yeah. Depends on the state they're coming from, of course. But
All right. The material we'll discuss today is on the agenda here. This will be a very conversational. We welcome your questions throughout the seminar. If there's anything that we don't cover, by the way, during the seminar, our contact information will be listed at the end. And I certainly welcome post-seminar questions. And Joe, I would imagine you're comfortable with folks reaching out to you afterwards if they have questions.
absolutely, shoot away.
Fantastic. So starting big broad topic here, common challenges faced by physicians and healthcare providers in private practice when it comes to looking for space, finding locations for the business, and then we can talk about some effective negotiation strategies to deal with those challenges. What would you say are the biggest challenges the clients you deal with face?
Well, I mean, it's usually a product of what they can afford, what they're looking for, and then the markets they want to be in. So that initial conversation that I'm having with doctors, it's a dream to find out what it is they're looking for, what their ideal situation is, and then it's a small dose of reality check saying, okay, yes, but we need to make sure that if you are looking for high visibility, if you're looking for a leasehold space, a retail center with an anchor tenant, lots of traffic. Landlords are know what they have, and anyone that's sophisticated enough to know what they have is going to know what they can charge for that space. So maybe bringing them a certain amount of an idea of what their monthly budget is and what it could potentially be, in order to get them into the space that they're describing is a little bit of an educational process. I'd say that's one of the bigger challenges, and also in a lot of markets and submarkets in Orlando is finding space. On the other end of that spectrum, the purchase end, some markets such as Windermere, parts of Claremont, Winter Park as well. There's little to no inventory available for what they want or what they need, and it's just it's a conversation about, hey, this might, you want to move in a month and a half into a fully built out space that is already turnkey for your specific medical need. That's not available out there. We can look for it and we can try to find it, but your timeline to get in there is probably a lot further out than what you might think.
And how much of what you are looking at focuses on the space requirements themselves versus the community around the space, whether it's in a medical community or patient demographic or factors such as that?
So you're asking so you're looking at the actual building itself, the building community, like what, a medical center, you mean?
Sure. So
Versus,
a client who is looking for a space, there's one conversation about the actual suitability of the space,
Mhm.
and then of course the area. Everybody hears real estate location. So how much of the conversation is also and what balance is the one that trumps the other one as far as the suitability of the location being either in a medical office park or
Got it.
near a hospital, near other providers that are similar or complementary, or if you're operating, say, like a concierge practice or a specific type of medical
Sure.
practice, the demographic, the
Demographic.
patient demographic in the area.
Yeah, and I think it's a little bit of both, and I think that's goes back to that initial conversation with the doctor and them dreaming, saying, "Hey, what do you want? You obviously you want some kind of synergy around you if you can with other doctors that might be a potential referral basis. It really it depends. Sometimes they might think that they're looking for a retail space in a Publix plaza, and then all of a sudden we gravitate to more of a medical office building set because it has the square footage that they want. They, will have to do either less or no build out at all because the space is already turnkey. It's a fluid situation that they're really going to have to address as we start to dig into the property or dig into the properties and the market, where they want to be a little bit more. So I would say it's a combination of both. I wouldn't say they lean one way versus the other in terms of how they turn out. I'd say it's almost 50-50. It really depends on what their palette is, what their budget is, and what kind of potential income that or production they can see coming out of the space that they go into.
So the flexibility would seem to be key for.
Yeah, I would say so.
And from a legal perspective, of course, one of the big challenge, not a challenge, but something we always keep in mind when we're talking about leases, regulatory issues with self-referral and kickback. And I don't want to dive too much down that rabbit hole, but that's if you are um, involved in a lease, particularly with a landlord or tenant who may be a referral source or someone to whom you refer patients, or if you're a physician with a space and you're renting something out to an MRI facility, you've got a potential regulatory issue there that you want to have vetted. You want to make sure you have a written lease, which I'm sure Joe would say anyway. You always want to make sure you have a written lease that spells out the terms, but there's legal requirements for that for self-referral law and kickback. And then negotiation strategies. What I always think about is in negotiations is what does the other, if you're representing a potential tenant, what are the landlord's goals? What's the landlord have in mind? The landlord wants security and they want to make sure they have the right tenant mix. Is that how you approach it as well?
Oh yeah, absolutely. You got to put yourself in the feet in the shoes of the opposite party in order to understand where they're coming from, and that helps you better define a negotiating strategy. Every negotiation strategy is different, but what it all comes down to is making sure that me, from my perspective, I want to make sure that I'm prepping my client for what they might see in a space. If it's a second generation medical space that's been on the market for a year and a half, 2 years, I think we can get a little bit more aggressive in our negotiating strategy than a space that's just coming on the market, that's fresh, gray box delivery, and they have more LOIs already, or they claim to, than spaces that they can put potential tenants in. So can we come in at $42 if they're asking $50 a square foot triple net on the initial ask? Yes, but I akin it to, let's say you have a car that you're trying to sell and you're offering $30,000 to it, and someone offers you $10,000 for it. Are you even going to respond to that offer? Or are you going to take it seriously? You want to come in. It's a conversation, really. You want to, and there are a lot of different asks that you're having on top of it as well. Your TI allowance, the free rent that you're going to have as well, or you're going to ask for your build out period to build out your space if that's necessary as well. There are a lot of different asks that are all going to be part of this puzzle that we're going to put together and present to the landlord. And we want to make sure that it's taken seriously and that they have the opportunity to respond while at the same time giving you the best possible chance of continuing that conversation and keeping it going. So, if it's the best remedy to that is having multiple options. If there's only one space and that's the only space in town that you can be, then, we're going to lead higher and more aggressive from our perspective than we would if you had 5 or 6 options and this is maybe the top 2 or 3. We have fallbacks, we have other opportunities that we're also negotiating on at the same time.
As I'm listening to you talk about availability and space and flexibility, it makes me feel pretty good about being in Central Florida right now.
It is.
I'm going to ask you to come back to a term that you mentioned, but I think in the next slide we talk about business terms. I'm going to ask you to come back to triple net.
Sure.
But we'll kind of stay on course with the slides we have. The landlord perspective. What do you see as the key issues that landlords are looking for when they're vetting tenants, when they're looking for somebody to come into their space?
Oh man, first of all, I'd say, making sure it works for the landlord too. Not only from a zoning perspective, but from a use perspective. If I have a dentist, you want to make sure that there's not already a dentist in that center, or if the center, if they don't have an exclusive agreement with that landlord, the center is big enough to handle more than one dentist. Are you comfortable with a dentist that's a general in there when there's already another general dentist in there? But from the landlord's perspective, does that work? Does it work with zoning so that they're in compliance? And then also, let's say for a veterinarian, for example, you don't want a veterinarian next to a library. Yes, there are issues, or there are ways you can mitigate the sound with the demising wall, but having somebody, bringing pets that are barking in and out when there's people try to read right next door, is that the best use for a center there too? So that's the big thing. And then also, making sure that at the end of the day, going back to what we were talking about with a landlord looking at a proposed use, or does it make sense for them? Bringing a tenant in that might not necessarily fit within the confines of what they're trying to do from a medical perspective is paramount as well. And does it make sense from their bottom line? Is this going to help them make their center more profitable or their location more profitable? Because at the end of the day, they're either using that for income on a monthly basis, or they want to package that up and sell it at a cap rate down the road.
And you mentioned something interesting that I want to go back to, which was you said if you're a dentist, you don't necessarily want to be in a shopping plaza or in a location that has another dentist, and that brings to mind exclusive use clauses. So that's a perfect example, and I just want to point that out, folks that are listening. If you are not familiar with exclusive use clauses and restrictions, all the more reason to talk to somebody like Joe, hire or at least work with a professional so you understand that. It's amazing how many times I think over the last 20 years I've seen situations where, like, how do you end up with these two tenants? Look at it, one puts the other one out of business, and they just had no clue that.
And that's not good for anyone. That's
Right.
not good for the landlord. That's not good for either tenant. You want to, if you're going to do something like that and the landlord's okay with it, you need to do your homework and make sure that there is enough growth potential and potential to tap into that market if you're a startup, or you have the ability to compete with the dentist in there to not necessarily grab business from them, but potential new business as well to support your business and also to support theirs from the landlord's perspective.
And so two dentists next to each other may not be good, but a dentist and an orthodontist,
Yeah,
or a pediatric dentist and a cosmetic dentist,
an endodontist or something
or
like that. Absolutely.
So complementary professions versus competitive professions. Definitions matter in that case when you're talking about lease drafting. You can spend a lot of time on exactly, narrowing those terms. Let's see, let's move on to the next slide. All right, top business issues for healthcare tenants. We talked about some of this, the surrounding businesses, the patient demographic. I may have you go back and talk about rent and leases, and can you expand on the different types of rent that you see in typical commercial leases, gross versus triple net? You mentioned triple net earlier,
Sure.
just so folks understand the distinctions and why they're important.
Absolutely. Yeah. And you're right. It is important to know what you're getting yourself into. And the three main or typical ones that you're going to see when you're out in the real estate world taking a look at different properties are triple net, which are typically predominant in new retail centers or in existing retail centers. And that just basically means those triple net expenses are your taxes, your insurance, sorry, real estate taxes, your insurance, and your common area maintenance fees, or CAMs, which are sometimes used synonymously with triple nets, but are inherently different. Your common area expenses, your common area maintenance expenses, so your lawn, the parking lot, a separate fund for roof as well, if the roof needs to be replaced down. Those are all packaged into that expense, which is typically on a per square foot basis. And advertised separately from the base rent that you would be paying. So for example, you go into a shopping center, a brand new one, and they're asking $45 a square foot for base rent. There's also, but it says triple net next to it. You need to ask what those triple net expenses are. Typically, they range from, in Central Florida, $3 a square foot to about $9 a square foot. Although I've seen them as high as $15, $16, $18 a square foot. So that's triple net expenses, modified gross, or we'll go to full service first because that kind of helps explain modified gross a little bit. That means everything's included within that. So typical office building, such as yours, for example, you might be in a full service lease here. That includes all of those expenses that we talked about already in that rental per square foot number. So if he's paying $22 a square foot right now, all of those expenses are included in there except your sales tax, not real estate tax. It's important to separate and know the difference between those two. So, and then modified gross is kind of the middle ground between those, meaning there are some expenses already included in that number, but maybe not your water, your electric. One of those or all of those are maybe janitorial separately. And it's important to reach out to the landlord at that time and ask them, hey, okay, we need to know what's included in that number. And that'll help you get an idea of what you're going to budget for on a monthly basis.
And so with a gross lease, it wouldn't be uncommon you're paying one lease price, but then as the expenses go up year after year, you see how that gets treated in the lease.
Yes, you're absolutely right. So and that I think goes into what we're going to talk about here down the road a little bit too, which is a cap on those expenses if possible.
Right.
And then there's you're right, there's typically a 3% increase or a certain amount of increase that the landlord can put off of your base rent or your base year amount on a year-to-year basis. And it's important, and this is where it really behooves you to get a good real estate attorney, is to try to protect yourself and cap that. Let's say the real estate taxes go up incrementally or a lot next year, and the landlord wants to turn around and he's going to make his tenants pay for that. Well, there's no protection for you if you don't have it in there already, that he can't raise it 4, 5, 6% with impunity, because that number's out of his control. But it isn't within your control if you're able to negotiate in a ceiling on that fee or on that monthly expense or on that yearly expense.
And we'll usually try to do that, negotiate a cap, or at least a cap on controllable, and then defining controllable versus non-controllable. Maybe they'll say, well, I don't have any control over the tax. I don't have any control over my insurance is going to be. But if you're paying on a triple net, and for several years you've been paying cleaning and maintenance, and it's one cost, and all of a sudden that cost doubles, that may give rise to certain questions, and maybe you're able to cap that in your lease. Also makes me think of another important provision is making sure that if you are in that situation, you have auditing rights. And so you have a right to ask the landlord if they say these are what the expenses are at the end of the year.
Yeah.
Make sure you have the right to get the backup documentation and verify that yourself. You should be able to take all of the expenses that are being passed through the tenant, figure out what your proportionate share of the property is, and then do the math and figure out what your proportionate share of those expenses based on the property proportionate share and what gets passed on to you, and
Yeah.
make sure that the landlord is correct.
Yeah, transparency, so if they're saying, hey, your TI or your triple nets are going up, and those expenses, whether it's triple nets like he was talking about or modified gross expenses, those are directly passed on, and then they ratify that at the end of the year too. So they don't necessarily know what those prices or those fees are going to be up front, but they do at the end of the year. So they're going to send you a bill possibly at the end of the year in a triple net lease saying, hey, actually our expenses were more than that, and this is the difference between what it was and what it would be, and we're going to add that into your monthly rent the first month of the lease, the next year. Or on the other side of it, if it's actually less than when they thought it would be, they could give you a credit towards that next month for the beginning of next year. So it's important to try to protect yourself if possible from that perspective.
Make sure you don't have any surprises.
Yeah, no kidding. Or you're able to limit the surprises.
I would envision that most of the times when you're dealing with a tenant, the a primary issue of course, the suitability of the space, size of the space, and then cost. Is that pretty accurate? What's this going to cost me?
Yeah, and it all comes down to a monthly basis, really. I mean, you're going to want to get an idea of what all those costs are going to be, and then if you're coming from a smaller space into a bigger one, do you have enough exam rooms, and are you going to be able to hire enough people to produce more to justify that cost too? So cost is one thing, but you want to put it in the context of what you can afford, but also what you can potentially produce out of a new space versus the old one.
And if I asked you, uh, what other business concerns should folks be more focused on in the beginning, or that you focus on that you're surprised that tenants who are shopping for space don't focus enough time on? Are the things that jump out?
I would probably have to say, think about that one for a second. That's a good question. From a monthly expense perspective,
Or just
real
from
estate,
a negotiating
or
perspective?
negotiating perspective, making sure that what you have, especially on a first generation space, or what you're going to get delivered to you, is in the landlord's scope of work that's in the lease itself. So is there an HVAC, an HVAC that's already included in your lease, or is that an expense that you're going to have to bring on? And you need to factor that into your build out if it's something that you need to do, including the ductwork. Is it a gray shell? Or if it is a gray shell, is there a concrete slab? Saying gray shell, vanilla shell, those are ambiguous terms because there's a lot of nuance and variance in what that necessarily means. So looking at that schedule is paramount, to make sure that you're getting what you thought, and your contractor and architect are allowing for that in the budget that they plan on giving you.
And when Joe's talking about the build out, I will tell you that in years past, probably one of the biggest areas of dispute that I've seen in the lease arena has to do with build out. Build out initially, both the cost and the timing. So oftentimes there'll be a credit for build out and then going over budget, and then the timing issue and what the effect of that is. How it affects the lease if there's delays in initial construction before you get into a space. These are all things that you need to plan for in advance, of course, because rare is the space. I would guess that you find a space and you're like, okay, I love it. I'm going to move into that next week, like a new apartment.
It is, yeah, it's very rare. You'll get those one in every maybe 12, 14 deals from my perspective. And, over the course of your professional lifetime as a healthcare professional, very rarely is that the case. And if you're able to find a space that fits within your budget that is already built out, and all you have to do is put maybe some new flooring and some paint on the walls, do cartwheels, because you're doing really well.
We'll talk about, I'll come back to some of the legal issues with a little bit of flexibility. These are issues that are on the slide now that I think really do have business components and legal components to them. And from the last slide and this one thing I wanted to have you expand on is providing options for the tenant, especially as far as expansion options, early termination, extension of the lease, potential purchase options. What types of what do you like? What are you seeing a lot? What do people request? And can you talk about those a bit?
Sure, a little bit from a you mean so options on as in not in terms of options in the market to find or different spaces, but
lease options.
lease options.
Correct.
Gotcha.
Yes.
So within the lease option themselves, I mean, I'm typically seeing, especially on 5 and 10-year deals, I'm seeing at least 1 to 2 options to extend, and then making sure you're either putting a scheduled increase into those options rather than leaving it open to the market. Or actually, that's really the best way to go, unless it's hard to speculate. If you leave that open to, market options at that time, you're opening yourself to, hey, you might be lower than what the market is currently allowing for. So if you're at $25 a square foot and you have and the landlord sees that you have 30 or a tenant signed next door with for $31, $32 a square foot, they can say, hey, look, I have somebody right next door to me or to you that actually signed for that amount. We want you at 29 or 30 instead of 26. If you have an option in place, they can't, and you decide to exercise it, they can't say no to that. They have to be open to the availability or the ability for you to go into that space or stay in that space. So if you put in an option where you're at 3% for, let's say, for example, and you exercise that option, then your next year is at 3% more rather than having to go up to market or what they perceive to be market, which is $31 a square foot as opposed to 25. So you're protecting yourself from that perspective. But conversely, if the market goes down and it corrects and all of a sudden it's 2021 and you're at 25 and you decide to exercise that option, you're at a disadvantage because you have to go up 3% in order to exercise that option. So it's really talking to a real estate professional is paramount, because while you can't predict where the market's going to be 5, 7, 10 years down the road, you can at least get an idea of what you're comfortable with and your risk assessment and value to that.
Yeah, but it's a little bit of a way to hedge if you lock it in versus just
It
see what
is.
the market delivers to you.
Yeah.
And from a legal perspective, I love trying to get as many options as possible for clients, for a tenant client. So if we can, if I have a client that thinks their business is going to grow, then we take on some space and then get a right to expand, at least the right to expand in a contiguous space on the same floor in a facility, a right to maybe relocate to a space that's larger, more suitable.
On that note too, what about, do you try to argue out landlords having the right to move you to a different space as well, or is that
That's a great point. So I've seen leases, most leases will provide, depending on the facility, the landlord has a right to move you to other space, and usually the language will be something to the effect of, space that's similar or equal to the space you have.
at their cost?
At their cost. You want to make sure that it's at the landlord's cost. And if you're signing a lease, if you picked space for a specific reason, if you're the type of practice where you're dealing with folks that don't want to travel in a building, and you're in a 4 or 10-story building and you need to be on the first floor, you may want to make sure that you can't get moved off of that floor. Or if you're in a shopping plaza, you want to be on the corner for some reason because it's easy access because of a handicap ramp or something. You may want to make sure you lock into that space before you get moved. You want to make sure that the landlord moves you if it's at the landlord's cost. I was reviewing a lease. I've seen lease language that says that they will remove you at the tenant cost, which I almost thought it had to be
Signatures of
that it-
misprint or something.
like a misprint, except it also allowed them in a tower to move the tenant almost anywhere else, and they were paying a premium to be on a high floor with a nice view, and next thing you know, they could be a year later in a parking garage. And you say, well, why does a landlord even do that? Well, they may in building towers, at least in my experience, it seems landlords prefer to lease a full floor to somebody, and you'll have certain tenants who want a full floor. In a shopping plaza, you may have certain spots that are on the front side of a plaza that are more desirable. So the landlord may want the right to move you into another location. And if it's important for you to be on the side facing the road or side facing the public, you don't want to be buried in the back unless either you're compensated for that, your lease rate comes down, there's some trade-off. So landlord option rights. I also, and I was able to do this during COVID, is negotiate not only rights to expand, but rights to shrink and give space back. So if you take on 10,000 square feet and halfway through your lease, it turns out that you don't need that much space, or with people working remote now, well, I don't think that affects healthcare nearly as much as other professions. But having the right to give up space and give it back to the landlord with a certain notice. Sometimes you pay a fee for that.
Sure. Sure.
And any other types of options that we didn't talk about that you've dealt with or had experience with?
Those are typically the options with medical spaces, especially medical office buildings, retail buildings, and sometimes flex spaces depending on the use and the need that I will run into. Are there any others that you typically run into from an option perspective?
Just sometimes purchase options.
Oh,
And
purchase
if you
options,
have a
yes,
purchase option, I'll say this and if you have your practice and you own the facility where your practice is, please do not have the practice own the building, because if the practice gets sued, you don't want to put the building at risk as an asset that can satisfy a judgment from the practice being sued. And I did have a circumstance years ago representing a healthcare client, I won't even say the practice, that had a purchase option. So signed the lease, was in the facility, and then the purchase option was in the name of the practice that signed the lease to buy it in that same name instead of creating a separate entity. Ended up in a fight over the purchase option. And now the practice is in a lawsuit over the enforcement of the purchase option with an attorney fee provision. So if you lose, instead of just having an empty shell entity that has a right to the building, doesn't get it, now you've got a valuable business asset that has risk.
Gotcha.
And so that was my purchase option scenario. Lawyers, I think, live out of like this, oh my gosh, I saw this bad thing one time, and you try to avoid that forever.
It does resonate and stick with you for a while. And I can assure you that happens on our side of things too, the real estate side of things as well. But to that option, that's a great point. The purchase options, especially, I mean, dentists, veterinarians, medical professionals in general, if you're in a building, maybe it's a single building rather than a large strip center, and you can see yourself down the road being able to purchase or wanting the option to purchase it, by all means, it makes a lot of sense to at least approach a landlord with that option to purchase down the road, or the right of first refusal, which we can get into here.
Yeah, and we have a note up there, and maybe if you could talk about a little bit about the difference of a right of first refusal versus a right of first offer, or an option, and kind of what they look all the same maybe to the layman, but they're a little different nuance. And what do you normally see, and what's your experience been with those?
So the right of first refusal usually entails they have the right, should somebody else approach the landlord to buy the building, that landlord legally, if you have a right of first refusal in your lease, has to go to you with that offer and say, hey, this is the offer that they're making. Do you want to buy the building at that price before we give them the ability, or before we go down the road with to have them buy it? And a purchase option is a more defined, hey, down the road at year 4, year 5, year 6, or whatever it may be within the lease, you have the ability to purchase it. You don't need some outside factor creating the ability for, or the option for you to buy the building at that point in time, if that makes any sense. Does that make sense to you,
Yeah,
or does that, yeah?
good explanation. And then I don't know that it would apply as much in a purchase scenario, but certainly in a lease expansion, right of first refusal versus right of first offer, where right of first refusal, as Joe said, uh, if an office opens up next door, we're going to put that out on the market, and if we get an offer, we have to come to you first and see if you want that space. Right of first offer would essentially say, before we put it on the market, we come to you, and it's usually at some preset amount. It may be what you're already paying per square foot,
That's a good
or
point.
some multiple or plus on that. Do you find that are landlords resistant to that, especially like right of first refusal, because they think it impacts their flexibility and maybe the value, the market value of what they're offering?
It can. It depends on the landlord. You know, if it's a mom and pop or somebody that's not typically an institutional landlord that owns, 20, 30, 40 or larger amounts of property throughout the United States or world, they're typically going to be more resistant because they will package up their real estate and sell it in groups. And that really it kind of gets in the way of what they want to do there from that perspective. Having a small piece of the puzzle being able to get in the way of a really large real estate transaction. If it's, a one-off owner that owns maybe one or two buildings, three buildings, and uses this as investment income, or it's the owner of the practice of the building who happens to be your neighbor right next to you in the plaza or in the building, it's much more likely to be able to get those factored into your leases, especially down the road. Whether or not there's any flexibility on whether they will allow you to define the purchase price up front, that's a different story. What do you typically see, Eric, when it comes to that?
Purchase price, I see the appraisal fallback.
Yeah.
Usually we'll get a qualified appraiser that will give the price. It may be some other fair market value, but it's usually an appraiser
At the time of the sale, or
at the time of the
at
sale.
the time
At
of
the
the
time of the
sale? Yeah.
sale. So we get one appraiser, or we each get our own. We get one. If we disagree with one, then we go out and we get our own appraisals, and then you have the competing appraisals. And surprise, surprise, the buyer appraisal always comes in
Yeah,
down here,
more
and the
than-
seller, and then they usually fall into it.
Yeah,
Or the
median,
other
yeah.
option is you start getting into a situation. I think when people start drafting these, that you don't think as much about how it's going to practically play out. And while it sounds good to say, okay, well, I'll get my appraiser, you go get your appraiser, they'll hire a third appraiser, they'll all be with the appraisal institute certified, and then they'll work together to give a price. Well, that's going to cost. There's going to be an expense in getting three appraisers to
Yeah.
do that. Maybe a better option is to say, let's try to agree on somebody, or if we can't, maybe we'll pick somebody, they pick somebody, and then those people pick one person. And then you pass, hey,
There you
you're
go.
gonna make a couple $100 to pick another appraiser, and then those professionals can agree this one person is qualified to give you the appraisal.
Gotcha.
Uh,
It's like almost like a moderator at that point.
yeah, it just sometimes people from a legally, what I've found as I've practiced longer is that people want less friction in their deals, and the lawyer doesn't want to be seen as somebody who's stopping the deal or getting in the way of the deal, and we also don't want the lease language. So there's sometimes the leases just have too much, in my view.
It's balancing between getting a deal done and actually making sure you're doing what you're supposed to do and protecting your client. So kind of informing them of the risk that you're going to be assessing in the lease, where you might be able to find common ground. And that's important from my perspective. Just a quick dovetail on that, why it's so important when you're looking at a real estate transaction to use a real estate specific attorney. Somebody, and especially if they have a lot of background in healthcare, it's akin to going to a podiatrist if you have a heart murmur. I mean, it's a doctor, yes, but is that really and truly what they do and what they specialize in? So making sure you have a real estate specific attorney that eats and sleeps leases, purchase agreements, contracts of that sort is paramount to getting it done, because there's so much nuance that goes into that. And it can kill a deal very quickly if you have an attorney that maybe your divorce attorney that you used, or you know, an attorney that you have on retainer for your business itself, yes, they can look at it, but it's important to have a set of eyes on there that really know what they're doing and what you can push back on and what you really need to say, okay, this is standard language for a lease, for example.
And
Yeah,
if you have a good quarterback, they can usually connect you with somebody
there
too.
you go.
So
Yeah.
everybody should have that quarterback, and they can connect you with somebody for a specific issue. I want to hit while we're talking legal issues, and this is a huge one. It's the thing at the top on our slides: personal
Yeah.
guarantees. Of course, if I'm representing tenant, I always want to be resistant to guarantees. There's some we can cap. There's some things that we can do if to maybe get out of them or try and limit them. What can you tell us, especially now with what's going on in the marketplace? What talk about personal guarantees? How many leases have them? How do you get out of them if you want to do that? Uh,
So in this market, from what I've seen, and I'd love to hear your opinion on this too, I've never been able to get a client 100% out of a personal guarantee. It's, I mean, if you think about it, going back to what we said about looking at it from the landlord's point of view, if they're, especially if they're injecting a large sum of money, let's say in TI to helping you build out a space, they're going to want some reassurances that they're going to get their money back should you default. Free rent, you know, you're modifying a space that they have that maybe is very marketable and attractive to other potential users. They're committing to you. They want to make sure that you commit to them as well. You sign you know, and correct me if I'm wrong, you sign a guarantee when you sign up for a credit card, when you buy a car, these are, or at least a car. These are all things that you're used to doing in that life. Now going back or in your life, going back to what Eric said there too, there are definitely ways where you can limit that guarantee. A lot of it depends on A, your financial strength, B, do you have a history of leasing or owning already commercial real estate, and C, what, you know, what kind of deal it is, the overall structure of the deal itself. What are you saying?
uh, Generally consistent. We've been able to now. I don't know lately if this has changed much, but when we've been able to avoid guarantees, a lot of it has to do with demand. You know, what are the market forces in play? How long has a space been on the market? How motivated is the landlord to get rid of it? And then also going back to what are the landlord's needs? Well, landlord wants to feel secure. So how do you make the landlord feel secure? Financial statements. I've had some luck with getting personal guarantees wiped from the lease, provided the landlord is able to review. But of course, reviewing financial statements implies or says that that tenant has already been in business. So if it's a tenant uh, with an established track record in business for 5 or 10 years, and now they're coming from somewhere else. But if you're a new business, it's going to be much harder.
Yeah.
If you have a name, if you are a name, a commodity, and you have a specific reputation, the landlord wants you in that space for a reason. That could be
A credit tenant
a
is what they
factor.
call it. Yep, absolutely.
And then it may not be personal guarantees to individuals. I've seen several, especially with a lot of bigger companies getting involved in healthcare, private equity groups, and uh, larger groups. I've seen where it's not individuals that sign the guarantees, but it's a parent company or an affiliate, somebody else with more assets who's
Absolutely.
signing the guarantees. And then if we are going to sign a guarantee, and one other substitute that works sometimes is a larger deposit. Okay,
True.
if I deposit with you, I've had clients, I did one not long ago, client deposited 6 months. I don't want to sign a guarantee, but I'll deposit 6 months of the rent. And so you've got a little pot, which a lot of times for a landlord
Are
is
they,
better.
is it a security deposit in that instance, or are they paying 6 months of rent in addition to the deposit up front?
And you could do the advance rent sometimes,
Yeah.
depending on the term of the lease, but this was a security deposit for 6 months. This
Gotcha.
was a 6 month security deposit. And with that 6 month security deposit, part of the rationale there is that if you're renting to um, a primary care practice or a podiatrist, somebody that's a small local practice, if they're not able to pay the lease anyway, they're probably going out of business and maybe going the path of a dissolution or bankruptcy. So you may have a hard time collecting anyway, because on most leases are going to have an acceleration provision, and you have years of rent. And so if you know you've got at least 6 months, that gives you a pretty good runway to get one tenant out and bring
And
somebody
new one
else,
in.
into the space.
Too
And
short.
then another option is to try to limit the extent of the guarantee. Either time, after 3 years, it'll be the guarantee will go away, or if I renew without the guarantee, or cap the guarantee. I'll guarantee up to $100,000, but nothing past there. And if you have multiple guarantees, if I'm representing somebody and it's a group practice and they're signing and you have 6 guarantees, maybe I say, okay, we don't all want to be on the hook for everything. I want to limit my exposure to a certain amount in case everybody else doesn't perform.
Like a rolling guarantee, for example. I've had a lot of success with clients that have asked for, they have a 10-year term in place, and they have 5, let's say they're able to negotiate 5 years of personal guarantee assured, and then after that you have a 12-month rolling guarantee where you're only responsible for up to 12 months of payment at a time. That really limits your exposure out of that after that amount of time. And I mean, another thing to keep in mind is if you're in the healthcare business, depending on what kind of healthcare provider you are, your risk is typically a lot lower than, let's say, a mom and pop restaurant that's going in. In a lot of cases, dentists, veterinarians, other specialists, you have less than a 1% chance historically of going out of business or defaulting on your lease. So the risk is relatively low, but all the same, you want to make sure you're mitigating that risk as much as possible.
I guess that's a good selling feature to landlords as well.
Yeah,
the lower default rate.
That's what we posture every day.
And one other thing on the guarantees, and I will push out, if don't have your spouse sign a guarantee, and there's several reasons for that, but if somebody asks to have your spouse sign, try to avoid that, especially if you are in a situation where you have one person that's a practicing professional drawing a lot of income and the other spouse is totally uninvolved. You can really limit your liability or expand it depending on having that spouse sign. Leverage and negotiations. We've got
We have a question. Can I get a question in here?
Okay.
So can you discuss the rule of thumb to buy out a lease short of expiration? My landlord and a major tenant want to offer me a buyout to end lease 3+ years early. What should payment consist of?
That's
Man.
interesting. So they want the landlord and a major tenant want the tenant to leave and pay them to leave early.
Buy out, yeah.
Okay.
So that's a great question. That's an attorney question, really, more than anything. But I mean, first of all, look, you want to have somebody review the provisions of your lease to see what that looks like, and then B, also, you're going to want to make sure that you have an option to be able to go and practice somewhere. So you want to go out, have somebody take you to the market right away and look at what it's going to cost you to replicate what you currently have somewhere else, and then factor that into the decision that you're going to make.
And use that. That's exactly what I was thinking. I don't know that there's a rule of thumb that I've ever heard of for that situation, but I would say you want to get with, Joe, somebody who knows the market, and figure out what's your total cost going to be to relocate somewhere else in a similar space, and then use that as your starting point for the negotiation on the buyout.
And that includes having a contractor involved in the conversation, an architect. If you have an equipment or medical supplier, have them involved in it too, because a lot of times they can draw up floor plans for you at little to no cost to kind of get an idea of what it's going to take to replicate that.
And then there's some issues as well with the timing. Are they looking for you to leave at the end of the month? Are they looking for you to leave at the end of the year? If it's 3 months, do you have the option to extend that? Because wherever you're going into, I'm sure Joe could talk about this a lot, but whatever is initially budgeted for the cost and the timing, it's not uncommon at all for those to change and to grow. So you want to make sure you don't affect your business and that you have some options moving forward.
Very much agree.
I hope that answered the question. If there's another one, fire 'em at us. I love the question.
Yeah, me too.
And then what do you have on the slide? leverage and negotiation. I think a lot of leverage is really the market. What you talked about in the beginning, market forces, um, and then reputation of the tenants, um, but the market itself, the demand of the building. Some areas, where we are, there's certain areas that are very high demand compared to other ones that are
Agreed.
driving market prices. And I think on that reason, this is more of a business question or a business issue for Joe. But when I talk to clients about things like this, they say, "Well, I want to be in such and such an area." Um, but if you don't have a lot of if you're not getting walk-in clients off people that are like, if you're not relying on the local demographic, if you're not a primary care physician that relies on, or a dentist where most of your patients are within a 3 to 5 mile radius, if you're a specialist, doesn't matter if you're in one zip code versus another zip code, if you can still service your patient population.
You're right. Accessibility is a little higher than visibility on your scale of requirements.
That's a good way.
Yeah.
That's great point. Way to express that. Optimizing lease terms for visits. So is there certain things that you say, okay, either the tenants want that you're trying to get, or things that you like? Do you have a special not a throw in, a special point that you bring to a lease? You say, all right, this is a deal that we got that maybe a lot of tenants don't think about, but that they're going to thank you for later.
Deal point within a lease
Yes.
itself. It's a good question. I would say a death and disability clause is something that I'll typically put in at the beginning at an LOI, just to make sure, not necessarily defining it from the beginning, what our expectations will be, but put that expectation in there that it'll want to be defined in the lease itself.
That's a great point. So, and that we'll see that in employment agreements. Most physician employment agreements will have some language about death and disability and tie it to the policy. You'll see it in shareholder arrangements with group practices, with key man language, and when is somebody required to retire, or when are they entitled to get bought out. What do you do if you have somebody who's a big producer, or somebody it brings in a lot of your patients come in to see and they can't work anymore? But tying that into a lease, that's a great point.
Especially in
the
LOI portion of it. My job is to make your job easier by getting a lot of those initial terms out of the way. LOI meaning a list of intent. So just like within other businesses out there, defining the main terms of the lease before you get the attorneys involved in actually defining the language surrounding it is paramount. And that's what you do. You're discussing in an LOI, it's a non-binding agreement where you're just going back and forth on the initial term or on the terms of it. So your base rent, free rent, what it's going to look like to build out the space, and how much time the landlord and the tenant are comfortable with. And then bringing that death and disability discussion in on the forefront of it makes Eric's job a lot easier, because it's already at the top of the landlord's mind. And if they know that they're comfortable moving forward with the LOI as it is, and that language is already in there, that tougher conversation about what a death and disability term. And can you kind of go into a little bit more what that looks like, what the death and disability terms are defined in a lease?
Sure. So you would essentially, it would give you some options to terminate early, or to reduce size. If you have whoever's driving the practice, essentially, is in medical, if your primary physician passes away and it's a physician-owned practice, that changes the entire dynamic. You could theoretically get another physician to come in and fill that role, or somebody to come in as a medical director to own the facility, or so that a non-physician could own the facility. But it complicates things. Or if the primary care provider, if I was talking to somebody recently, a dentist who had to have surgery, who had an injury and had to have surgery on his wrist, so he's out of work for a while. If you have something that's more permanent, where I've seen it is generally in that context would be a more permanent disability, that would enable you to essentially terminate either terminate early, or maybe give you rights to sublease it, find another tenant, find somebody else.
Or rent abatement if it's a
Sure.
short term too. Maybe
So-
put that on the back end.
You could have, yeah, that would be, and then maybe tie that into insurance as well.
Yeah.
So that if you're on a 5 or 10-year lease or something, and you have a period of time when the primary care provider can't, or the primary healthcare provider cannot generate income, you get a break, so you don't essentially go out of business or go into default. And you made a point, actually, when you're talking about LOIs, and it brings us to a nice segue on this last, fostering, positive professional relationships. I have seen, I always look at the letter of intent or the LOI as that has the main business terms that you've already worked out. So Joe has worked out business terms between the tenant and the landlord as far as what the rent's going to be, what the term's going to be. It's non-binding, but those business terms provide the framework for the lease. I am resistant to trying to renegotiate business terms when you get into the actual lease. And when clients do that, it always makes me a little bit uncomfortable. I've got to serve the client, but I always feel like there's a little, it's not negotiating in good faith. It's okay, we got a deal locked in, we know it's going to work. But now as we're signing, we're finalizing a lease, wait a minute, I want to change the rent. Usually that's done. It's not binding, but it's not done. What can you say about the non-binding nature of a letter of intent and how that affects the relationship with a landlord and tenant?
You're right. It's the framework of what the lease is. It's superimposed over the lease, and all of the legal language that will be binding is filled in around it, along with a bunch of other important things to hash out and work out as well. And it does, when you're kind of opening Pandora's box a little bit when you go back to retrade deal points that have already been approved by the landlord and yourself in the LOI. Yes, it's not binding. Yes, you can go back and do that, but then the landlord's going to go back, or potentially could go back and say, well, if you're going to do that, then I want to go back and talk about free rent. If you want to talk about going back on, on base rent and coming down another $1 or $2, then I want free rent to come down, and then it just goes back. Sorry, I should have turned that off before we started this. But so it really, and then you spiral and mire yourself into a situation where this could go out, or this could continue to go back and forth for months at a time, when the opportunity cost of you getting a lease signed, starting your permitting process, and getting the build out done so you can get in and start producing and getting patients in faster might be much more valuable for you, the time to get that done, than it would be for you to negotiate another month of free rent. So you really just need to kind of get an idea of what it is that's important to you and try to quantify that.
Well, you always want to have good communication with parties. We mentioned that in the beginning. Communication, if there's issues, talk out the issues. Demands have their time and place, but initially having good, honest communication. I think that starts with the initial negotiations, the LOI, good faith on the front side. If there are issues questions that come up, trying to talk through those first. And I think that will, if you're struggling, if you're a tenant, if you don't have a disability clause in your lease, but you have an issue, try and get in front of that issue with your landlord. We saw a lot of that during COVID, really.
Yeah.
When it just, the reality is when all the businesses were closed, tenants were never going to make the rent, but the landlords are relying on that rent to be able to get financing. So how can we get that done? So there was a lot of horse trading that went on during COVID.
But that was a very interesting time for you.
It was actually mostly positive.
Okay.
COVID was mostly positive because I saw, it was nice to see people were flexible. Like, okay, how about if we do this? I've done things on leases where, okay, we're gonna reduce the rent a substantial amount, but then on the back half, we're gonna start raising it higher later, or we're gonna toss in a percentage component later. Now, healthcare, let me just say, percentage lease and healthcare, the whole fee splitting issue, please don't do that without talking to an attorney. But there are businesses, if you're not a physician, There are maybe if you're a supplier or something else where you can do things more creative with the rent. But trying to be a creative problem solver before getting the attorneys screaming at each other, I'll look and see who's on the other side of something and try and have a good dialogue before trying to blow something up.
Yeah, that makes sense. It's a lot easier to hash things out with someone that you're familiar with and you know their how they work and what their end goal may be. I'm sure than it is to work with somebody who you have an adversarial relationship with, or you don't know from the get-go, but nobody can pick that really.